Hello and welcome everyone. Thank you for being with us today. My name is Katie Joseph. I'm the Director of Policy and Advocacy at Interfaith Alliance. We are a national policy and advocacy organization that works to advance an inclusive vision of religious freedom, one that protects and celebrates people of all faiths and of no faiths. Together, we are going to have a conversation today about the case Fulton v. City of Philadelphia, religious freedom, and the new Supreme Court. We are, of course, awaiting a decision in this case any day now, and we're joined by three incredible experts and insightful thinkers and advocates to help us get a deeper understanding of what's at stake in this case, and more broadly for LGBTQ folks, for non-religious people, and for religious minorities across the country. So before we dive in, let me introduce our panelists. First and foremost, we're joined by Weston Charles-Gallo. Weston is an outstanding LGBTQ+ advocate for foster youth. He also highlights the importance of same-sex couples who foster and adopt. He's a former youth ambassador for the Young Leader Award, and he's also a current student at Pittsburgh State University studying communications. So thank you for being here, Weston. Sharita Gruberg is the Vice President for the LGBTQ Research and Communications Project at the Center for American Progress. She's an expert in advocacy, law, and policy issues affecting LGBTQ+ people. And she also has extensive experience in immigration, as well as providing direct service to those in immigration detention, refugees, and asylum seekers. And last, of course, we have Mark Joseph Stern, no relation, who is a staff writer at Slate magazine covering courts and the law. Mark is often one of my first stops for legal analysis and the political dynamics that are going on behind the scenes at the Supreme Court. So it's a real honor to have him here with us. So thank you for being with us for this conversation today. We will be together for about an hour with an opportunity for audience questions towards the end of our conversation. Given the size of today's call, our panelists are going to remain in presenter mode, but please feel free as we're talking to submit your questions through the Q&A function at the bottom of your screen, and we will get to as many as we can. So let's get into today's topic. Any day now, as I said, the Supreme Court will issue a decision in Fulton v. City of Philadelphia. Oral arguments were heard in the case all the way back in November 2020, and they focus on the city's decision not to renew a contract with Catholic Social Services to provide foster care and adoption based on their refusal to certify same-sex prospective parents. So all contracting agencies that work with the city in this space, both religious and secular, are expected to comply with the city's human rights law, which prohibits, among other things, discrimination on the basis of sexual orientation. When CSS made clear that they would not comply with that requirement, the city declined to renew their contract. So CSS then responded by suing the city of Philadelphia and made the case to the judge that the city had violated the free exercise clause of the First Amendment and sought a renewal of their contract for foster care by the city. That first judge sided with Philadelphia, and on appeal, the Third Circuit of U.S. Court of Appeals affirmed that decision. We're now, of course, before the Supreme Court, which will take on this question and potentially render a decision that will have far-reaching consequences. Now, in that brief summary that I provided of the case, you heard a lot about stated interests of both the city and Philadelphia and concerns raised by Catholic Social Services as the provider. But in that framing, those who actually bear the burden of this dispute, youth in foster care, are so often left out of the equation. So Weston, I'll ask you, if you will, to start us off. You have frequently spoken about the urgent need to connect LGBTQ youth in foster care with affirming homes. Will you talk a little bit about how you came to do the work that you do and what you see is at stake in this case?
Yeah, absolutely. So I began advocacy at 15 years old, and I joined a support group for foster care youth in Kansas City. It really just started as a support group that kind of transitioned to more of an advocacy group where we, ended up going to like panels on high schools, and we went to a conference, the one-time conference, where we really shared our individual stories. And then I was seeked out by someone who came to that conference from HRC, and then I later became a youth ambassador for them, speaking and doing engagements and doing things like that. And then I was connected with an organization called Foster Club, where I was recognized for my LGBTQ work and, foster care advocacy. And then was connected with an organization called Family Equality, where I was actually able to further, share my platform and share my story and actually begin doing work like this. I really started doing this when I realized that there was a crisis within LGBTQ youth in the foster care system. So, there are 400,000 youth who are in the foster care system, and 30% of that do make up the LGBTQ youth population. And so already then with that information, you can see that, LGBTQ youth in the system are already, underrepresented. And so I really noticed that from facing discrimination firsthand, that there was something that needed to change. I had a hard time finding affirming placements due to being a gay Black teenager in a very rural community. I was from a population of like 850 people. And so it was really hard for me to, feel a connection or to even find affirming placements that would take me in, with the fear of, turning other kids gay or, very inappropriate behavior. And so with that kind of against me, I really thought that I would never even find a forever family. And so I was in a residential facility on the means of emergency shelter because they had nowhere else to put me. I, faced, depression and anxiety, although I didn't have behaviors. So there really was no reason for me to be in an emergency shelter at a residential, but it was pretty much just because I needed a place to lay my head. And, I was the ward of the state. They can't discharge me to the streets. And so that's pretty much where I was at. And so I got a call from my worker that I would have a weekend visit. It was with my two dads, and I've been there ever since. And so essentially on the verge of suicide, my two dads really saved my life.
Thank you for sharing that experience and the incredible role that foster and adoptive families play in supporting youth. I think that often there is, again, in this focus on agencies, sort of glossing over of the fact that by and large, when young people go into the foster care system, they don't pick the agency that they work for.
No.
Their contract is assigned to, their case is assigned to. And so for LGBTQ youth who, as you said, Weston, are overly represented in the foster care system, a placement with an agency that will not be affirming or that will not place with households that are affirming can only compound that damage. That is so much more true for folks who are in rural areas, but is also an issue even in more urban areas like Philadelphia. So let's talk a little bit about Fulton and some of the arguments that have been made back and forth. So Mark, this is where I'm going to turn to you if I can. Catholic Social Services frames their case as a matter of free exercise, and even went so far as to suggest at oral arguments that certifying homes of prospective same-sex adoptive couples is akin to quote-unquote compelled speech in violation of their religious views. This is going to sound familiar to folks who kept an eye on the Masterpiece Cake Shop decision or even the Little Sisters of the Poor. But the arguments made may be even more far-reaching given the implication of taxpayer money in this case. So help us understand a little bit, what are the legal questions at play here?
Yeah, so Catholic Social Services, or CSS, the plaintiff here, has made a couple of different arguments, all of which are, I would say, on dubious grounds under current law, which suggests that this could be a case where the Supreme Court could really dramatically expand the rights of religious organizations and agencies, and even potentially businesses, to discriminate by citing their own religion. So, as you said, CSS claims that they're being compelled to speak in favor of same-sex marriage. They're also arguing that they are being targeted by the city of Philadelphia because of their religious beliefs, and that the city of Philadelphia has engaged in anti-Catholic animus by declining to renew the contract for CSS to continue to screen prospective foster parents. Now, it's important to note that Philadelphia actually maintains a very robust relationship with CSS with regard to a lot of other social services, including other aspects of the foster care system. So CSS still operates a congregate care home where multiple children in foster care currently reside. CSS does a lot of other stuff for Philly. The one thing the city said you can't do is screen prospective parents, because the agency will turn away same-sex couples. And it's not that difficult to see that if one of a limited number of agencies with the power to screen same-sex, all couples, turns away same-sex couples, that agency is shrinking the pool of potential foster parents who are out there and qualified to take in children. That's sort of Philadelphia's main theory here, that the city really wants to get these children placed in foster homes, and that if an agency is refusing to work with certain kinds of prospective parents, it's going to make it harder for these kids to get placed somewhere in a loving home. And then third, CSS makes this argument that the Supreme Court's longstanding decision in Employment Division versus Smith is wrong and should be overturned. We don't have to get too much into the weeds here, because I think it's pretty likely the court will outright overturn Smith. But basically, back in 1990, the Supreme Court held that a generally applicable and neutral law that happens to burden religious exercise is usually going to be constitutional. It's not subject to heightened scrutiny. So to take the example from that case, if a state bans drug use, but a certain religion uses drugs as part of a ceremony, the state can still punish those folks for using the drug, even though they were doing so for religious purposes. The state didn't set out to target them. And so here, if Smith is still good law, this should be a pretty easy case, because, you know, the facts do not suggest, at least to me, that Philadelphia passed its anti-LGBTQ discrimination ordinance or non-discrimination ordinance because it was like trying to discriminate against Catholics and trying to single out and punish Catholics for their views. Philadelphia passed this non-discrimination law because it valued LGBTQ people, including as parents, and wanted to make sure they had equal access to the entire range of social services, including foster care. So that's sort of the mix of the law that's on the table here. And I think the odds are, the better have suggested, that the court will probably hold that Philadelphia targeted CSS, that Philadelphia went out of its way to punish this agency for having Catholic views. That's something that Brett Kavanaugh strongly suggested at oral arguments, that he accused the city of Philadelphia of looking for a fight. And so I think that's probably the theory that's worth engaging with the most here today, and potentially in the coming weeks when this decision comes down, because the Supreme Court has dramatically expanded the amount of conduct that it considers to qualify as targeting religion, as expressing hostility toward religion. You know, during COVID, we saw a majority of the court hold that it was hostile to religion, that it was discriminating against religion to close churches and not liquor stores, even though churches bring hundreds of people into close quarters for hours, and in a liquor store, it's a few people in and out in a few minutes. You know, the Supreme Court is desperate to find any evidence of discrimination against religious people and religious organizations. It is just scrutinizing as closely as possible every record in every case so that it can claim this status of victimhood for religion and use that to grant sort of special extra rights to religious organizations. And I think at bottom, that's what's going on here. We have CSS arguing, you know, we have a right to take taxpayer money, to use public funds to discriminate against same-sex couples. And by denying us that right, Philadelphia is expressing anti-Catholic hostility. That's the theory that's sort of at the heart of this case. And unfortunately, I do think that's the theory the Supreme Court will adopt.
And this is the real challenge here, because for organizations like ours, when we think about religious freedom, we think of kind of both sides of the coin. There's both freedom of religion, the right to believe as you choose, the faith that you choose, or to be non-religious without facing discrimination on that basis. There's also the right to freedom of religion, the idea that religion will not be imposed on you. There will not be a religious test for office or an expectation that you comply with a certain religious test to access benefits and services. And that requires a certain balance. How do we ensure that folks are free to believe as they choose, while also recognize that one person's freedom can interfere with another's to do the same. And so, Sharita, this can be a tough spot in how we think about and talk about promoting non-discrimination for LGBTQ folks. And I think it's important to note at the outset and say very clearly that this idea that there are people of faith on one side and LGBTQ folks on the other is just false. There are many, many, many LGBTQ people of faith. There are many, many affirming religious folks who are not LGBTQ themselves, and many organizations, child welfare organizations even, that work with all people, regardless of sexual orientation, gender identity, or religious affiliation. What we're looking at here is an attempt by one agency to pick and choose between beneficiaries based on their own religious test, and to use taxpayer dollars to impose that test. What is at stake for LGBTQ folks in Philadelphia and beyond?
Right. That's a great question. Contracts is to provide the service and to make sure people who are in need of these services that the government is providing can access them. It undermines the whole purpose if the providers refuse to provide the service to people because of non-merit factors. And that's exactly what's happening here. And so, to quote the great liberal legal scholar, Justice Samuel Alito, or not Alito, but Scalia, if we allowed something like what CSS wants in this case, it's not going to be possible for government to function. It's not going to be possible to really have these services provided in a way that meets the goals of government providing the service, because everyone who is providing them gets to pick and choose what rules to follow. And that's not sustainable. We have 443,000 kids in the foster system in the US right now, and same-sex couples are 7 times more likely than different sex couples to foster or adopt. And so when you're arbitrarily denying people opportunities to assist and foster and adopt kids because of their sexual orientation, that is limiting the ability to place kids, the ability for the state to provide the service that they're providing in this case. And for LGBT folks more broadly, we're really concerned about what the court could do in granting a license to discriminate, and how that impacts not just the ability of LGBT folks to foster and adopt, but access a whole range of critical services that people need. And so the Center for American Progress last year fielded a national representative study and found over 1 in 3 LGBTQ people had experienced discrimination in the year prior. And for trans folks, for people of color in the community, those rates were much, much higher. And this is in so many areas of life too. So for over half of these experiences of discrimination happened just, going to public places and spaces, restaurants, things like that, just living their lives openly. And as a mechanism for avoiding discrimination and the trauma associated and stigma, LGBT folks avoid accessing critical services. So for example, we had nearly 1 in 5 LGBTQ folks reporting that they avoided getting services that them or their families needed to avoid discrimination. And when we're talking about medical care, something as critical as that, the numbers were even higher, with many people avoiding doctor's offices. And for folks that had experienced any kind of discrimination in the year prior, again, that increased to nearly 1 in 3 LGBT folks were avoiding services that they needed just to avoid discrimination. So there's a real harm here because we have people who have experienced discrimination, are wary of putting themselves in situations where they would be subjected to the harm of discrimination again, and as a response are foregoing really critical things that they or their families need just to avoid the trauma of discrimination. And a ruling from the Supreme Court in favor of Catholic social services is going to make it even harder for LGBT folks, rather than being able to rely on non-discrimination protections and their right to access services. They're going to be increasingly hesitant to even try, because they will know that they might be refused or denied. And I think a lot of cases, it's not that you can just go down the street. We saw this in Masterpiece too. For a lot of folks, particularly rural folks or people in the military who live near bases in rural areas, there just isn't another provider. And so we found that nearly half of LGBT people who live in non-metropolitan areas said it would be very difficult or impossible to find an alternative adoption agency. And overall, 2 in 5 LGBT folks reported it would be very difficult or impossible to find an alternative adoption agency. It's not that you just have another provider nearby that you can go to. And this is true for a number of critical services. 2 in 5 LGBT folks reported that it would be very difficult or impossible to find an alternative homeless shelter if they were denied. Again, a ruling from the Supreme Court might not just apply to adoption foster, it might be broader into a range of key services. 1 in 5 LGBT folks said it would be very difficult or not possible to find an alternative mental health professional if they were denied services. And so the implications of the Supreme Court's decision in this case could be far-reaching and really cause harm to LGBT folks in a broad range of areas of life where folks are just trying to live and access the services that they need.
I think that study is so important because this is often something that we hear from supporters of the case being made by groups like CSS, that someone can just go somewhere else. In oral arguments in Fulton, this point came up again and again that, well, they've never had a same-sex couple come to them and be turned away, so this isn't even a problem. But folks know, like, if a place is not going to be supportive or affirming or is going to turn you away, especially when you're in need of something like medical care, you're not going to subject yourself to that, and the consequences can be really devastating. I think that it's important for us to think about as well that not only do these types of barriers affect LGBTQ folks, but we've seen child welfare providers in states, for instance, like South Carolina, use these tests to turn away folks based on their religious affiliation. So for instance, Miracle Hill Ministries, which was a similar state partner that was getting taxpayer funding, implemented a requirement that prospective foster and adoptive parents and even volunteers had to sign a statement of evangelical faith and provide documentation of the church that they attended. And so for a Catholic applicant who wanted to be a volunteer with their program, as well as a Jewish applicant, they were turned away because they did not meet this religious test. And in those circumstances, we see a similar situation where a member of a different faith tradition is being told, well, you can go elsewhere, even though their taxpayer dollars are funding the service. that is being provided and they are seeking to participate in. So South Carolina is not the only state that has embraced this type of kind of permission for faith-based child welfare providers. But we've also seen some really positive developments in the states that do keep the focus on foster youth. And Weston, you were involved in some of this work in Missouri and ultimately creating a foster youth bill of rights that was signed by the governor. Tell us a little bit about what that process was like and why it was so necessary.
Yeah, so like I said, I was a part of an organization called Youth Speak Out. And so it was a collection of all of us kind of really working together and thinking about what we really would have wanted as, youth in the system. And so I think one thing that was really important for us to really talk about was the normalizing of childhood experiences. At that time, you needed permission to be able to sit and with friends, to join in different organizations at school. And so often it felt like we were trapped, we were used, we didn't ask to go into foster care. It's not like a burden or a punishment to be in care. Unfortunately, we just didn't have, parents to take care of us. There's just different situations for all of us. And so I think it really boiled down to really thinking about what we would have wanted while we were in care. And I think that the experience was so empowering and rewarding to know that I was able to contribute to something as I was a former foster youth in Missouri, and thinking about how I can help other people and their journey through the foster care system that unfortunately is so broken.
Yeah. So as we're thinking about both what's happening at the state and the federal level, Mark, you started to get into what we're seeing as a developing doctrine of religious freedom under the current court. And the COVID exemptions are perhaps a really good example of this. But maybe you can talk a little bit more about how far. I love the quote that Sharita lifted up from great liberal lion Antonin Scalia about what happens when you create these types of exemptions. What direction are we going here? And what should be a matter of concern, particularly for folks who are members of minority faiths or LGBTQ or other marginalized?
Yeah, so I think that one decision that gives us a forecast into what's going to happen at this Supreme Court is called Espinoza versus Montana, a decision that came down around this time last year. And so that was before Amy Coney Barrett replaced Ruth Bader Ginsburg. So this has been going on for a while. Barrett has sort of turbocharged the process, but the other 5 conservatives were already pretty much there. And Espinoza is a kind of difficult case to describe, I think, because the holding is so bizarre. What happened there was that Montana had this program that, through this kind of complicated tax credit process, used public funding to support private schools, specifically religious schools. And the Montana Supreme Court held that it was unlawful for the state to give public money to religious schools. And so the Montana Supreme Court struck down this entire program. So the program had given money to both religious private schools and secular private schools. The Montana Supreme Court says, this is so wrapped up in this problem of funding religion that we're just going to strike down the entire program. No taxpayer dollars for any private schools. The Supreme Court, by a 5-4 vote, forced the state to revive the defunct program, arguing that really the Montana Supreme Court had engaged in anti-religious animus by striking down the funding program because it funded religious schools, and arguing that the Montana constitutional provision that bars the public funding of religion was itself sort of anti-religious animus, hostility toward religion that could not comply with the First Amendment's free exercise clause. And so the court resurrects a dead government, optional government program just to ensure that religious schools can continue to obtain taxpayer dollars. And there's a lot that's weird about that. One thing is this idea of the Supreme Court issuing a decision forcing the government to resurrect a program, which is kind of similar to what's going on in Fulton. I mean, if we take a step back, it's very odd to have courts forcing cities to renew a contract that expired. Like, that's not usually something that happens. You can't really imagine a trash collector like suing Philadelphia and saying the city was so unfair to us by switching to a more competitive like bid, so we're going to sue and have the courts force our contract to come back to life. But the other weird thing about Espinoza is that the court did not care at all about the interests of Montana residents not having their taxpayer dollars going to the funding of religion, and expressed absolutely no interest in the children who will now be sent to religious schools that are publicly funded, that are extremely devout, that teach all kinds of anti-scientific theory like intelligent design and creationism, and that, most pertinent to our conversation, are viciously anti-gay, anti-LGBT. A lot of the schools that are currently receiving taxpayer money in Montana, thanks to the Supreme Court's decision on Espinoza, are explicitly and sort of grotesquely anti-LGBTQ. They cruelly punish and mock and try to destroy the lives of students who are gay or transgender. Some of them won't even allow a heterosexual student with gay parents to attend the school. And I think it's really interesting that the Supreme Court had no cares in the world about those children and no interest in the taxpayers who did not want to fund religion, because less than 20 years ago, the Supreme Court wasn't even sure whether it was constitutional to use public funds for religious schools. There was a whole line of cases where the Supreme Court had actually limited the use of public money to support religious schools, because the court said, well, this is a problem with separation of church and state. This is a problem with the Establishment Clause. You know, it kind of goes back to like James Madison and Thomas Jefferson, that governments are not supposed to use taxpayer money to fund religion, and it's a freedom of conscience issue, not just for the religious folks on one side of it who really want that money, but also for religious and non-religious folks on the other side who don't want to be subsidizing religion. Think about a Muslim who doesn't want to subsidize, evangelical Christian education. Their rights of conscience are being violated when they're forced to subsidize a religious practice that they do not adhere to. And the Supreme Court used to care about that, and today it doesn't at all. There's just no interest in the other side of the equation that you were discussing earlier, Katie. And I think that is a pathology that has infected Fulton from the very start, where the Supreme Court views the interests as all lying, or at least the conservative majority views the interests as all lying on one side of the equation, that all of the interests flow towards CSS, that's the agency that has been harmed, that's the party that needs court intervention, and nobody else matters. Taxpayers don't matter. Children don't matter. Prospective parents don't matter. They are secondary or tertiary parties here. And above all, at the very top of the constitutional hierarchy is this agency that demands taxpayer money to discriminate. And again, I really do think it's a pathology, and I think it shows profound disrespect for religious minorities and non-religious people who don't want to be subsidizing this kind of discrimination rooted in religion. And I think it's really deeply unfortunate that we have a Supreme Court that so blithely dismisses the interests of pretty much everyone who isn't a conservative Christian with views that happen to align with 6 of the justices on the court today.
Gotten to a really frightening place with the current makeup of the court. And I'll remind folks again, if you have questions as we're going through our discussion here, please use the Q&A function. We will do our best to get to all of them. Let's look forward a little bit. First, I'll go to you, Sharita, and then I'll go to you, Weston. Sharita, in the work that you do, there's both analysis of what's working and what's not working, and then sometimes, perhaps more frequently these days, we get to think about where we want to go what are our recommendations for protecting people of all faiths and non-LGBTQ folks and non-LGBTQ folks alike? So how are you thinking about in your work protecting true religious freedom for all, as well as LGBTQ?
Sure, and I do want to lift up, a lot of faith-based providers aren't discriminating. Like, we have Bethany Christian Services just announced, they're going to serve everybody equally. And that is, we know a lot of faith groups, that is what their faith tells them to do. The problem is when you are allowing federal, or taxpayer-funded entities that are providing services to pick and choose what rules to follow. As someone who is seeking services, you're not going to know, when I walk in your door, am I going to be treated like a human being? Am I going to be served equally? Or am I going to be discriminated against because of who I am or what I believe? And it's because of this that we need the government to enforce the same rules for everybody and ensure that in this enforcement, that the main goal of having these contracts and services is that the recipients are able to access the services that they need. And, the easiest way to do this is through non-discrimination protections, through these clear rules that are applied equally. As you said, this also benefits people of faith. As we saw with Miracle Hill in South Carolina, it was Catholic providers or Catholic parents who were being discriminated against. It was Jewish parents who were being discriminated against, prospective parents. And by having this basic standard that applies to everybody equally of non-discrimination, you're ensuring that LGBTQ folks, that Muslims, that Jews, that women, that everyone who is in need of the services is able to get them and not be denied for non-merit factors. And this, this puts everyone on equal footing. It's not discriminatory. It actually is ensuring that we're combating discrimination. And so, what Philadelphia had in place is actually the policy that we should be seeing. It's treating everybody equally, and it's not punishing folks who aren't going to follow it, but it's saying, if you're not going to follow our rules that to ensure that people access the services that we're here to provide, then we're not going to pay you to provide services because you're telling us you're not going to help us actually serve our communities. And so this isn't complicated, or it shouldn't be. The government's not here to pick and choose whose values and whose beliefs they're elevating. It's to provide the services and to make sure that folks are able to access them.
Exactly. And I think that, depending on the extent of the decision that we get, whether it is a narrow or a broad one, there is work being done in Congress to start thinking very seriously about how to address discrimination in foster care and adoption, discrimination on the basis of sexual orientation, gender identity, religion, and household status, folks who may be single as opposed to applying as a married couple. And Weston, you actually recently testified before a House subcommittee about this work and the promise of a particular bill in accomplishing these goals. Do you want to share a little bit about that?
Yeah, absolutely. So essentially, like I said earlier, like on the verge of suicide, my two dads saved my life. So if it wasn't for my dad's, not being turned away, I might not be here to actually talk to you today. And so I really believe that turning away same-sex couples from fostering and adopting harms all children in the child welfare system, with same-sex couples 7 more times likely to foster and adopt than opposite-sex couples. So therefore, they're being turned away, kind of like my dad's, and other couples like them. That would mean that there would be fewer families available to actually foster and adopt. So same-sex couples are also more likely to foster and adopt older kids like me, large sibling groups, and children with disabilities. So essentially, before meeting my two dads, placements in a rural community that were open and affirming to gay, biracial teenagers were, non-existent. And so, I was told by my worker that there are, potential placements that were disrupted because of my identity. And so, with so much pain for my past, I found that, testing the limits, with my fathers and things like that, and they never really failed me. I think that turning away same-sex couples will definitely mean that there are fewer affirming families for kids like me who are LGBTQ youth. And so I really want people to remember that foster children do not get to choose which agency serves them. So all agencies must affirm LGBTQ youth, and discriminating against LGBTQ adults undermines that. And so I really want to really consider that the lives, future, and the outcomes are more important than the personal beliefs of adults. And I think that we're not asking, for individuals to change their beliefs. We're simply asking to be affirmed and loved for who we are. And so the John Lewis Every Child Deserves a Family Act requires training for all adults in the child welfare system. And I truly believe that faith-based agencies can live their faith and also provide equal treatment to LGBTQ families and foster parents and children. And many agencies have already done this, as it was mentioned before, that Bethlehem Christian Services just changed their policies to allow same-sex couples to foster and adopt. So essentially you need to think, like, why can't agencies do this? And then I really want to say that I think that non-discrimination is a foundation for LGBTQ kids, and I think that non-discrimination essentially saves lives.
And there is an incredible coalition that is working to move the Every Child Deserves a Family Act. Weston is on the youth leadership team. This is a bill that really centers the needs and experiences of youth in foster care. And if folks would like to learn more about the coalition, hear stories from folks in your state who have fostered or adopted, you can go to everychilddeservesafamily.com. I will include the link in the chat here in just a moment to get a sense of just how much can be done for foster and adoptive youth, particularly LGBTQ kids in care. So as we've been talking, we have had a number of questions come in. So switching gears slightly, I will direct our first question to you, Mark, if that's okay. The current makeup of the court is heavily representative of justices from two faith backgrounds, Catholic justices making up a supermajority. Do you think that will affect how the Fulton, how we're thinking about religious freedom?
So what I will say is that for whatever reason, the conservative majority, which is, as you mentioned, made up of Catholic and Protestant justices, seems to lift up and value certain religious beliefs that happen to align with their own. Now, I don't know the justices' hearts. I don't want to, make any kind of psychoanalysis here, but it is striking that these justices seem to read into the Constitution guarantees of certain rights that they themselves would like to hold and seem to personally view as important, and are willing to disparage or dismiss or ignore other values and other beliefs. And those values and beliefs that are ignored or disparaged tend not to align with those justices' own personal views. Relatedly, I want to address a question that was asked in the chat, which notes that the mayor and commissioner in Philadelphia made a few attempts to persuade Catholic Social Services to work with same-sex couples, and made some very, very mild statements to try to kind of figure out if there was any room for compromise. For instance, I believe Commissioner Figueroa said something like, the Pope has expressed openness toward same-sex couples. Does that affect your thinking, or would you move more in that direction? And the plaintiff, CSS, considers that to be anti-religious animus. It's very similar to what we saw in Master's Cake Shop, where a commissioner on the Colorado Civil Rights Commission said truthfully that religion has been used throughout history to justify discrimination and was condemned by the Supreme Court, and actually by a 7-2 vote, as hopelessly hostile to religion. And to bring in another case recently, a panel of judges for the Sixth Circuit Court of Appeals held that a professor has a First Amendment right to misgender a trans student in the classroom, to use that student's incorrect pronouns and gender identity in the classroom, and condemned school administrators for talking with him and asking him to maybe consider not using the wrong pronouns, and condemn those conversations as evidence of anti-religious animus. And I think if you look at all of that together, what we're talking about in the frame of religion also applies if we frame it as speech, where the Supreme Court views religious speech, which, in, you know, whether it's using incorrect pronouns or refusing to bake a cake or refusing to support same-sex couples fostering, they view that kind of speech as really at the top of the hierarchy of constitutional values. But other actors with legitimate interests in these disputes who try to present the counter-argument, who say, we think that you should use the correct pronouns, or we think that religion shouldn't be used to discriminate. Those individuals are condemned as hateful bigots who despise religion, and their speech is really downgraded. There's no concern at all for their own free speech right to express their views here. Instead, they're just sort of smacked down as, you know, again, like just irredeemable bigots who hate religion. And I think that that further illustrates the fact that the Supreme Court is effectively sort of gagging individuals who have objections to public funding for religion, individuals who have objections to the use of religion to discriminate, folks like me who don't believe that religion should generally be grounds to discriminate. Our speech doesn't matter to the Supreme Court or to many conservative judges. And whether you want to call this a kind of modern blasphemy law, as Terry Blackwell did in the comments, or you want to just call it sort of a myopic view of freedom under the First Amendment by the conservative courts, it's just impossible, I think, for courts to lift up certain religious views and certain expressions of religious faith without denigrating other religious views and other expressions of religious faith, including non-religion. And I think that's going to be a huge problem, because it's really tilting this debate toward folks who want to discriminate. It's giving them unlimited, then tying the hands of those of us who would like to present the counter argument that perhaps using religion and using public funds to discriminate is not a good thing under the First Amendment.
Well, and also, this is the same Supreme Court that didn't find anti-Muslim animus in the Muslim ban.
Right.
Like, as a Muslim, it just blows my mind how readily they find animus in really innocuous laws or statements, and yet don't in after everything Trump said about Muslims, in like he'd managed to clean up the racism just enough, or the anti-Muslim animus just enough, that they thought it was fine in his third attempt, even though it was still a Muslim ban.
So given the makeup of the court and that very recent history, we may get a more narrow decision in this case, or we may get a very broad decision in this case. But the next question, if I can actually direct it to you, Sharita, is for folks who are invested in this question, if we see a decision for CSS, broad or narrow, what is the next step?
I mean, it depends. I'm really hoping that, even if there is a decision in CSS favor, it's narrow, because the alternative is really hard to imagine. It is so hard to imagine how we move forward if the government says that, these faith-based providers can pick and choose which rules to follow. but I'm an optimist. I'm hoping that's not the case, and that we can still move forward on pushing for comprehensive non-discrimination protections for LGBT folks in the Equality Act, and every child deserves a family, and the other protections that we need. Also, as I said earlier, a lot of providers are affirming. The National Center for Lesbian Rights just launched an incredible campaign called We Serve with Love, that lifts up LGBTQ affirming faith-based providers. And these are not one-off institutions. There's a lot of them out there. And so I think, no matter what the Supreme Court does, it's going to be so important for affirming to providers to be really vocal and clear that they serve everybody, that they're not discriminating. Because as I said, LGBT folks are, have a lot of trauma from experiences of discrimination, are wary about going places. So, making sure your website has content that makes it really clear that you're not going to turn away LGBT folks, that your statements, that you're coming out and showing up and joining campaigns like We Serve with Love, and being really clear that what CSS is doing is not what so many providers believe, but we need folks to speak out and be vocal and affirming, in addition to the policy solutions that make it clear that discrimination is not going to be tolerated.
And it's been amazing to see on that point in particular, there are a lot of really loud voices around this particular issue that surprises no one. But recent polling shows that broad majorities of Americans support non-discrimination protections for LGBTQ people. And PRI recently found that 70% of Americans would oppose allowing taxpayer-funded service providers to discriminate on the basis of religion. And this is maybe a little bit of my editorializing, but I think some of this may come from this notion that, as Mark noted, that my taxpayer dollars are providing that service. And so there's both a question of implicating my conscience in discrimination that is likely inconsistent with my own religious beliefs. And there's also a question about what if my child wants to go to a school that's being paid for with taxpayer dollars, but maybe turned away because of who they are or who I am, for that matter. And so these are broad-based questions that we're dealing with here. And I see that we've had a couple of folks chime in different ways, including at least one law student who is listening in. I feel for you. These are really important questions to continue for many years to come. And there was a specific mention of protecting interests of people who are non-religious or atheists to ensure that there is freedom from religion alongside the right to freedom of religion, which is critically important here. So the next decision for the Supreme Court is tomorrow. We are expecting decisions on Mondays and Thursdays over the next few weeks. There is a possibility that we may see additional days added to that calendar, but we will stay tuned. Interfaith Alliance is partnering with NEAT and many other organizations in sponsoring a decision day set of activities. So for folks who are interested in learning more, please go to decisionday.org. There will be rapid analysis of the Fulton decision. When it comes down, there will be an online rally, either a celebration, a commiseration, or some combination of both, as well as more in-depth analysis later in the day. So I will share the link to that as well. And before we close, I am just going to ask each of our amazing panelists, first and foremost, thank you so much for being here with us, for sharing your expertise, your experience, your wisdom, and I will just ask you if there is one thing that you would like folks to keep in mind as we await a decision in this case. And I will ask, if I can, for Mark to go first.
Sure. So I would ask everyone to remember that the pendulum swings. It is probably currently swinging to the right. I suspect that Fulton will be a devastating decision for many of us. I think it will be very degrading and upsetting, and I think it will have absolutely awful real world harms, but it's not the final word on the matter. There will be ways to limit its damage legislatively in some states and some cities, and it should galvanize people who maybe haven't been paying attention to this to fight even harder for fair courts that are diverse and representative of the country that they actually serve and are not dominated or captured by individuals with a sort of narrow and discriminatory set of beliefs. So as bad as Fulton may be, it is not the end, and it's up to us to make sure that it does not stand as the last word on this so-called clash between LGBT non-discrimination and religious freedom.
Sharita, what would you like folks to?
I mean, I agree with everything Mark says as usual, but also I'm so heartened by the data that you lifted up about it. Most people support non-discrimination protections. Most people support LGBTQ equality. Most people support ensuring that even faith-based providers are serving everyone equally. And no matter what the court does, it's going to be incumbent on all of those voices to be really loud and clear with our elected officials that they are supportive of LGBTQ people, of LGBTQ youth, of non-discrimination, and of pluralism. And so that's kind of the power that we all retain no matter what the court does. And it's going to be important for everybody to be very vocal about supporting these policies and supporting these protections.
Wonderful, absolutely. And Weston, we'll give you the last word.
Yeah, so I really just want to say, just end by what I said earlier, that I really just urge people to understand the lives, the futures, and outcomes are so much more important than the personal beliefs of adults. And I also want to know that, as it's been mentioned before, that it's not the end. And I think that these are things that, can set us back, but also, being able to elevate voices and understand that to be vocal and to take a stand on how and what you believe in. And anything is possible. And I believe that the protection should be in place, and one day they will be.
Thank you so much, all of you, for being here. And as we await a decision, keep in mind that it's not up to this court to determine the value and dignity of who our families are. And that true religious freedom and LGBTQ equality are complementary, not contradictory values. So to learn more about our work at Interfaith Alliance on this issue and many more, you can go to www.interfaithalliance.org. My name is Katie Joseph, and it has really been such a pleasure speaking with the three of you, and thank you again to everyone who joined us today.